What is up, guys? It's me, Muddy McFly, your Swedish Attorney General for Goon Squad Productions. Fresh off the press, I haven't even read it yet. It's the motion in Yarid v. Ocwen. Let's delve straight into it. Motion to deny the defendant's request to dismiss case. Okay. I, the plaintiff, George Yarid, like previously stated, open a mortgage on my property on December the 6th, 2005, paying an interest rate of 7.25, and for my insurance additionally. The originally lien holder mortgage and bank changed 3 times over in the span of their said mortgage. Originally with Nova Star Mortgage, then sold to Saxon Mortgage, and then sold to Ocwen Mortgage. In January of 2009, I fell behind on my mortgage and asked for loan modification. It took 6 years of being behind to finally have loan modification granted, reducing my mortgage from $1,398 to $786, which was doable. This occurred October 2015. Then they raised it back up to over $1,000, adding in my forced place insurance and flood insurance, which wasn't necessary to pay. Fuck, this is hard. I made mention of paying the insurance separately and FEMA at a later date. After 4 consecutive payments, I fell behind due to the issue of the mortgage going back up and the current tenant bailing on me paying their rent, which in combination caused me to be behind on my mortgage. No, George, that didn't cause you to be behind on your mortgage. You not paying your mortgage caused you to be behind on it. You didn't need tenants to pay your mortgage. If you've got a mortgage on a house that you can't afford, sell the fucking house. Idiot. Throughout this endeavour, I made partial payments to give something, with only discovery they were being placed in suspense account and not being applied. I strongly stressed them in obtaining a new modification, which they mention I had to wait 2 years to be eligible for another modification. Throughout this period, I've made several attempts to come to a resolution with them in trying to get them to do the right thing. I've exhausted every possible way to get them to work with me. I strongly believe that Ocwen and the Bank of New York Mellon haven't followed practices of the Fair Debt Collection Act. Also strongly believe that they made false representation in connection with the debt secured by the security deed on my home. Also stating that they weren't the original loan holder, requesting them to show the note on the property. Again, I have no remedy at law to redress the harms complained herein, and the sale of my property under the circumstance of a record which was contrary to law, equity, justice, and good conduct by all parties, their said being motion. Jesus Christ. Facts of current case. Recently I filed a lawsuit against the mortgage company, bank and trustees to save my property from foreclosure. The lending institution has not tried any remedy to work with me on and new modification, because they don't have to. They're not obliged to. Currently, I would qualify for a new modification. After my bankruptcy was finished in April, I reached out to my mortgage company for an solution to resolve the issue of honouring the previous mortgage. To no avail, and the outsourced company in India that handles the mortgages weren't willing to help, and deceiving me with information of my property not being foreclosed, only to find out it was weeks later. I tried reaching out to the lawyers and they weren't able to help in the matter, so I filed a lawsuit and memorandum of lis pendens with Henrico to stop any ongoing auction in my house. I wrote them a letter and notified them back in July when it was filed. I stated I would remove the memorandum of lis pendens if they would be willing to work with me on honouring a brand new modification. I have every intention of trying to work out this situation. I plan to do whatever is necessary to keep my property. Even though the bankruptcy Chapter 7 wiped the debt clean, I have every intention in keeping my childhood home. I have no current obligation in the property, only the strong desire to obtain and keep it. In this particular case, I believe the defendants didn't act according to law, nor were willing to work with me, the plaintiff, on a resolution to this case. Something to note here, when you're doing this sort of stuff, you've got to show law. You have to cite bits of law that say why they haven't done this, and show an example of something that hasn't happened and provide evidence of this. Not done. Recommendation, resolve in case. I would be willing to drop the case if the mortgage company is willing to grant me another loan modification. I strongly urge them to honour previous amount of $786 per month. With agreement, I would remove the list pendants off of the property. I've been trying to come to some resolution in this matter, and I believe if they agree to this, and it would be to everybody's best interest in handling the matter, upon that being granted, I would dismiss the charges on my end, even though I still do believe they violated practices of the fair debt collection. Again, I have exhausted a great amount of time and energy. Now I open this option on the table for review. Jury trial requested if no resolution can be given. Like previously requested, I request a jury trial in the matter of prayer for relief. Again, I strongly urge the courts and all parties involved to accept my request or any other offer to remedy this case. If no agreement can be made, I ask the courts of the previous request and nominal damages as the court sees fit. I plan to keep the list pendants on the property until an agreement of some sort can be offered from the defendants and or decision being rendered to the courts and or trial in my favour in this particular matter. I haven't obtained attorney, so I also ask the courts to grant me time with any other facts there said deemable. Oral trial once again requested. Lastly, if any adverse ruling is made, I ask for time to be able to renew my list pendants to any appeal, if so needed, upon any adverse ruling. I think my resolution to the matter at hand is more than reasonable and doable without any long and drawn-out legality. Straight order to proceed with workable situation at the matter at hand. If not to proceed with more discovery on the matter, I respectfully ask for this action in advance and respectfully hope for a ruling in my favour in advance. Cordially yours, George Yarid. It's so confusing, guys, because he's supposed to just respond to their motion to dismiss, to say why it shouldn't be dismissed, and set out why his case exists and what case law supports it. And he doesn't do any of that. He just seems to focus on if he rants and rants and rants about the same things, and he doesn't actually deal with the matter at hand and go, right, this is what they haven't done because the law says they have to do this, and this is the bit of law that says that that's the case, and this shows they haven't done it. He's not actually responding to the motion. He's just writing a bit of paper. That's all he's doing. He writes a bit of paper with just the same stuff that he had already done. He argues again. And it just makes no sense when someone is so desperate to save their house that they won't actually deal with the facts and deal with the matter. And this is case in point with this man. He refuses every single time to actually deal with issues. Instead, he skirts around it with, oh, my life's so bad, look what everyone's done to me, and it's always someone else's fault. It's never his own fault. He cannot take responsibility for his own actions, and he refuses to acknowledge that he has caused himself this problem, no one else. It's a ridiculous situation. And for him to be in this position and not even be able to recognise that in himself just speaks volumes as to who he is as a person. Guys, it's a quick one because it's late here in Sweden, but I've got this out to you. More when it appears, but as you can see, Yarid is barking up a tree that is not going to win. From what I can tell of my knowledge of this, I can't see this being approved. I can't see this even being an argument against the motion to dismiss. And I would imagine it will be dismissed pretty soon. And George has made it quite clear that if anyone dismisses anything, he's just going to take it straight to appeal. So this is no way over and done with yet, guys. I have been Marty McFly. I have been reporting for YaridWars. We are the Resistance.